So we are live now. Am I audible?
Okay. Yes, yes.
Yeah. A very good evening to one and all present here, ladies and gentlemen. I, Atin Handuja, CEO of Legal Foxes, welcome you all to workshop on legal notice drafting. Today we have expert on this topic, Advocate Lalit Ajmani. Sir has drafted various legal notices and uh, he is currently practicing in Delhi High Court. I welcome you to the session, sir. Uh, as we are running
Thank
out
you.
of
Thank you.
time, I would like to request sir to start with the session. Over to you, sir.
Okay. Thank you, Adan. Thank you for inviting me on this important topic, that is the drafting. I would say that it's the first stage of drafting any kind of document. As a junior or as a person, when you enter in this profession, this is the first thing that most of the seniors provide to their juniors to begin with, because this is not a lengthy draft, and of course, this paves the way, which gives a good exposure to the lawyers as well as to the students to actually know the nuances of legal notice drafting. Now, before I go ahead with the details of legal notice, I just give you a brief as to what we are going to discuss in this whole session. So, in the first part, we are going to deal with the basics of drafting as to why this drafting is so much important in the legal scenario. As to when everybody can write, and there are nowadays almost every third or fourth person intends to write something or blog some or to have his or her own blog. And thereafter, when the parties are themselves aware about the facts of the case, and when, of course, in certain scenarios when no law is required, then why this drafting is so much required, and why do lawyers and even the teachers, seniors, focus on this thing. So that would be the first part, and thereafter we will begin with the legal notice as to whether the legal notice is required, whether it mandated, and in what scenarios legal notices is preferred to be drafted. And thereafter we will begin. We will discuss the various facets of legal notice drafting. Though it's not a lengthy draft, but there are certain things that a person should take care while drafting legal notice or while drafting anything. And thereafter we can, in the meantime also, and at the end we can have questions and answers from the concerned people. Now, to begin with, why drafting is so much important, the basic rule is that whatever you write, whatever you submit to the court or to the other party, it will sustain and it will live throughout the period. It says that man can die, but not the document. That is why this drafting is so much important, because you may not have the evidence regarding the conversation, regarding the allegations, or regarding anything that you or the other party have said, but the drafting or the letter will always sustain. And even if the original document will not be there, but there would be copies, there would be circulations of that. So that's why this is the base of the entire litigation, or the entire dispute, I can say. So this is the first reason why drafting is so much important. And thereafter, when we go into the technicalities of law, we understand that there are so many technicalities that we need to take care of while drafting anything. For example, in civil dispute, it is important that a civil plaint needs to be verified at the footing of the plaint. And in some of the cases, people or lawyers are, or I would say the parties, skip this thing, and that can prove detrimental, or at least that can stretches the time that they are seeking to shorten, because that is a mandate provided in Order 6 of CPC only. And thereafter, if I talk about Order 37 of CPC, there are certain requirements which you need to mention in your plaint. So, if you do not take care of those mandates as provided under law, your plaint or your notices, or whatever you draft is not going to help you. In fact, that can be fatal for your client. And at the same point of time, we also need to take care of that once you submit anything to the court, it is not necessary that you can amend it again, because it will be the discretion of the court to allow you the amendment or not. Just Sorry, I'm not keeping well. That's why I'm having this. Okay. So we also need to take care of that. At the time of drafting the this is- sorry, yeah. So once you draft something, it is not necessary that the court will allow the amendment, and it will become the discretion of the court whether to allow the amendment of. Sorry, yeah. So whether the court will allow the amendment or not. So once you submit, make sure that it's your best draft and you should understand the basic of it and not just litigation. In fact, in law firms and in consultancy services, the drafting is so much important because you need to give the opinion, not by verbal communication, but also sorry, it's a bad cold right from the morning. Okay. So yeah, as I was talking about that, even in law firm, you have to draft a lot of notices, lot of opinions, and if you are not well versed with the drafting, and if you are not well versed with the email as to how to write an email to your senior, to the client in question, to the query in hand, then I guess that it would be very difficult to sustain and to grow in a law firm environment. And for all these things, that the legal notice is something that comes in the mind when we tend to begin with legal drafting course. I'm so sorry. I think just a second. Yeah. So this is something that that you can begin with. We in law colleges, in national universities, and in every prestigious college, we have the courses of drafting. But at times, what we have experienced and what I have experienced also, that what we were taught is the base, or is something that can only be inculcated when I draft something which is of import, which is practical in nature, or when I understand the facts of the case. Because in colleges and in various courses, and I would say in various books of sorry, yeah. So in various courses also, and in various books, we begin with just drafting without having any factual details, without understanding any particular sorry.
Lalit sir,
Yeah, just a second. Yeah, I think the cold is taking toll. I was fine in the morning, but since just in from the morning the cold session, it's taking toll.
so shall
I
you
think
postpone this workshop?
sorry.
Shall you postpone this workshop, or like?
I think now we can continue. I think that we can spend another half an hour or 40 minutes on this topic, because it's already I've covered the first point, and now I think that I can do it, because in the morning also I have attended a couple of courses. I think that I can do it. Yeah. So yes, so this is basically the gist as to why the drafting is so much important, and this is the best way to learn drafting also. And I have seen, and a lot of juniors have told me that there is a fear in their mind that they have to draft something, or whenever the drafting project comes in, there is certain kind of fear whether they would be able to do it or not. And of course, that put a lot of pressure, because senior will say that and senior, I won't say often judge, but senior actually can appreciate the efforts of a junior or a junior lawyer, or in fact, the client can appreciate the effort only when you can provide a good draft, or or something that they can rely upon. Because as I told you earlier, that you may change the arguments, you may not have evidence of anything, but definitely draft will be there. So this is very important, and it's that's why a lot of importance is being provided is being given on drafting. Now, moving forward, as to now we understand that drafting is something that almost every field of law requires. So why we are taking this legal notice drafting as such? Because uh, as a legal notice is something that does not require the detailed appreciation of facts, the detailed appreciation of law also. But in this session, actually, we can understand the basic gist and various parts of the legal notice as to what we need to consider while drafting it. Now, the first question comes into mind is actually what is legal notice? So, legal notice is basically nothing. It's just an intimation from party A to party B regarding an alleged offense or regarding a dispute that is survived that is there between the parties. So, and the legal notice also says that it is just a warning, I would say, or an intimation that a party intends to settle the matter or intends to highlight his grievance before proceeding ahead or before going before the court of law. So this is a first step that can convert into a litigation, that may not convert into a litigation, but this is definitely, I would say, a strong message to the other party as to such and about the alleged offense or about the alleged transaction, and the intention of the other party that party A can take any action if the alleged compliance is not being complied with by the other party within the stipulation period of time. Now, in law, there are at least one part where the legal notice is mandated, that is the Negotiable Instruments Act, where you necessarily have to provide a legal notice to the other party under Section 138 of NIR. Whereas in other parts of law, it is not mandated. Even it's if it's a civil dispute, it's not mandated. So, and if I'm not mistaken, DRC Act also talks about the mandated legal notice to the other party for vacation of the suit premises. So, apart from these isolated events, the law does not mandate, and law does not say that a particular party needs to give a legal notice. For a reason maybe that it's common endeavor of everyone that the litigation and the war is always the last option that they would like to cherish upon. So I think that due to all these reasons, the notice is not being mandated. And the other thing why the legal notice is often not being followed by the clients also is that it again stretches the band up to 15 to 30 days, because they will approach the lawyer will take a couple of days to draft the notice, then he will send the notice, then it will take another 1 to 2 days to reach there. So 5 6 days would be the sorry, yeah, 5 6 days would be there, and then another 15 30 days for the other party to react upon. And most of the scenarios, the other party does not pay heed to the legal notice. At max they can reply, or at max they can just call and ask for the stretch or ask for the mutual settlement things. But in my own personal experience, the legal notice does not provide you any I would say the particular thing that a party is looking for. So in generality, it extends the time limit, or it extends the time that a party has to face while recovering the money, or while taking the appropriate action against the defendant or the accused, as the case may be. However, having said so, there are certain new instances, even for me, where the legal notices have produced a wonders for the concerned parties. For example, in defamation suits. Now, recently, in my own personal briefs, I am counseled with a particular scenario where party X has been defamed by party Y. Now, party X, because that what happened in their official capacity, in their professional capacity, they did not prefer to approach the concerned court. They rather preferred sending a legal notice and asking for the apology. Now, asking for the apology and sending a legal notice definitely shows the intention of party X, where they say that yes, party X acknowledges that yes, he has been defamed, but he does not want to take action. So rather than going into the litigation, that may, of course, that may help him to get the compensation, but that will take a lot of time. Whereas if we consider the gravity of the situation where both the parties are at very shaky stage because both are working on a professional front and are somewhat related to each other, so in those cases the legal notice have produced wonders and have saved, I would say, a lot of years and a lot of time and money, of course. So it cannot be denied that the legal notice is now obsolete or is of no use altogether. One other example could be that if you are aggrieved by some shopkeeper or by some retailer about anything, rather than going the consumer court, it's always suggestible to send a legal notice, because if the amount is not so big, the other party may think, let's settle the matter, and they may take the grievance seriously if they were not taking by then. And thereafter, there are certain other scenarios where this particular thing may help. For example, in as I told you that in rent situations, and now recently Delhi High Court has said that due to COVID, the lessee cannot take the shield of COVID-19 as a force majeure clause unless and until it is specifically provided in the contract of that lease deed. So as we talk about, there are certain scenarios where the legal notice uh, is appreciated. Now that allow us to come now to the third question as to when the legal notice should be given, and whether the legal notice is viable or not. See, I would say that if it's mandated by law, you have to do it. There is no point, and there is no question of debate over there. But when it is not mandated by law, I would say it is upon the two things that a council needs to take care of. First, what is the need of the client? What is the client actually looking for? For example, if the client is looking for the compensation and he does not care whether he will spend 1 month, 1 month, 1 year, or couple of years, then I think that legal notice is not is a wastage of time, because as I told you that it will at least take 1 month, and then you can proceed ahead with the litigation, and that also gives the opportunity to the other party to get ready and to see that a particular action may be taken against him or her. So this is something that a person needs to take care of, because uh, while sending something to the other party in legal scenarios, that will have certain repercussions and you will be bound by that. And in second scenario, if I say that a person wants to take a chance, and if he's not sure, and if he's very skeptical about the litigation, whether he or she should go ahead with litigation, or you think that that he or she is somehow apprehensive about the litigation scenario, then I think the legal notice is not a bad option altogether, because that allows both the parties to understand as to exactly where they stand, whether they would like to go ahead with the litigation process, or whether there are certain scenarios where they can work upon and settle the matter, or get whatever they are looking for. So there are certain scenarios that allow the particular council to utilize its discretion and wisdom to send legal notice. And one more thing that we need to take care of: whatever you need, whatever you draft in legal notice, you are always bound by that. You cannot take the contradictory stand in the litigation if that is followed by the by the legal notice. That suppose if you have said that the X has taken money from Y on 1st of January 2020, you can't say that in 2019 he has taken the money instead of 2020. That will hamper the case. And now we will discuss about the details of legal notice as to what needs to be drafted, and what are basically the subject matter, the I would say the parts of legal notice which a person needs to take care of, and how much details are to be there. So through this we are coming to the, I would say, the gist of this session as to the drafting part of legal notice. See, always this is a common, I would say, bad practice, if I can say so, that not only just young lawyers, but even the law students or the lawyers who are in practice, they tend to rely upon the existing drafts only. So suppose if I have to draft a legal notice, I will rely upon some draft, and then rather than applying my own mind, wisdom, or rather than doing my own research, I somehow rely upon that draft, and do it, and by doing it, I definitely save a lot of time. But what hampers is that the peculiarity of the case that is not appreciated by me first. Second is of course a detrimental effect for the lawyer that he hasn't done its part. And the third thing, that there are certain drafts nowadays that are now obsolete. We don't need to follow those drafts. So in certain cases, those, suppose for example, if I have to draft a legal notice for recovery, and there are certain drafts, and there are even if I Google that, anybody can find a legal notice draft for recovery of money. But what I can miss if I over rely upon those drafts is that uh, uh, we need to very technically see as to what facts need to be mentioned in detail, and what we may not highlight at this point of time, that may create problems for us. I'm not saying that that you should hide material facts, or you should lie to the court. That is definitely not the thing that I am hampering upon. But what I am hampering upon is that in legal notice you just need to appreciate certain kind of details only, that allow the other party to get the message as to what you are looking for. And in legal notice you don't need to go into the details of the facts, for the simple reason that that it's just an intimation regarding the regarding the particular offense, because both the parties are already aware about the facts of the case. You don't need to go into the details, because at times that in first or second meeting the clients may tell you A, B, C, D, suppose they are the facts, and then in fourth, fifth, sixth meeting they will tell you that these are not the only facts. There are certain other facts also, that A1, B1, C1, D1. So during conversation also, especially when the client is quite emotional regarding the subject matter, that could happen. Despite the best of his or her efforts, that can happen. So we need to rely upon the facts what we have, and what we want from the other party, rather than totally relying upon the draft. This is the common mistake I think that a lot of people have been doing, and they are still doing. So this is something that a person should not do. So now I think now we can begin with the drafting. So if you see that in legal notice, the first line or the heading is the way, the mode by which this legal notice is being sent to the other party. So just a second, Yadana. I'm so sorry. I wasn't anticipating this turmoil of my. Just a second.
Not an issue, sir. Not an issue.
Hmm. Yeah. Apologies for all these inconvenience. Though I'm still there's nothing need to worry about that. It's just a normal cold that has triggered since morning. So yes. So now we will begin with the drafting aspect. So the first part is that we see that that in the beginning it's written that the mode of the transfer. uh, Again, I take the example of the other notices. It says that speed post, AD, RC, and so on and so forth. Slash slash slash. So you don't need to write all these things. Now you need to consider what is now being prevalent. It is of course the speed post that I also suggest that a speed post should be there, because that is something that the court rely upon, and a party may not be able to dispute the other party. The second is Gmail. You write email slash email, and then you write the WhatsApp if you have the phone number of the other party, and you send it by WhatsApp also. So sorry. So rather than stating those modes which are not even which are not even useful for sending the legal notice, there is no sense of writing all those modes. So that may not hamper your legal notice at all. And sorry. Hmm. That may not hamper your legal notice at all. But once again, if what's the need of writing something that is so obsolete? Because as a legal person, as a legal professional, you need to understand that whatever you write, that should make sense. Otherwise, you can write the entire story without any sense. So I focus on that. Every word should make sense, and there should not be even a single comma in the legal notice that is not warranted. So and this is the first step, and this is something that I learned from my own experience, that if we start focusing on these minor details, that actually helps us to focus and to bring that focus on the paper, so that everybody can read it and say, okay, this is the point and this is the detail that is required, not here or there. Now thereafter we come to the date. Date is very important, and of course the reference number. If we see that, if my office is sending, so I send the reference number also. It is nothing that, for example, if I say that it's a file number or case number of that particular year, so that's the discretion. So reference number is not mandated. You may skip that altogether. And then of course followed by the addressee. Now addressee, there can be couple of address. So you mention the person name. For example, if it's Mahendra Singh, so Mr. Mahendra Singh, son of so and so. If you are not aware about his father's name, so you don't need to mention son of so. Its residential address is important. And then if you are also aware about the place where he works, you can mention the that also at working at so and so place. But once again, you need to understand whether you need to mention it in the legal notice or not, or whether you can skip it. Because there may be government employees, there may be certain scenarios that, that if people are working in the same office or at the same place, and you don't want other people to know that you have already initiated some legal services or some legal steps against XYZ person. So in that scenario, you may skip that step, and then of course you write the email address and the Gmail. Now this is related to what we have written over there. Suppose if we are if we know the phone number of the other party, we definitely mention the WhatsApp. And if you are aware about the Gmail address of email address of the other party, then you should mention in the mode that it's all served by email. So that's how it makes sense that when you have the concerned information, you have also intimated to the other party that he can't take the defense that he did not receive any legal notice, because the WhatsApp and the Gmail and the email thing cannot be refuted very easily. Now this is the first basic thing that every notice should have. Thereafter, the important thing comes into picture, that is the subject line. Now, subject line should not be very lengthy. It should be stated that whether for example, if the legal notice is under Section 138, that is the check bounce litigation, you just say that legal notice under Section 138 of Negotiable Instruments Act. You don't need to say that on a legal notice on behalf of so and so against Mr. So and so for this. No, it should be one line, or I would say uh, four, five, six words, whatever. So, and suppose if it's not mandated, if it's related to defamation, you can just simply write that seeking compensation legal notice seeking compensation for defamation. Or if you say that, that it is related to some matrimonial dispute, you can say that legal notice seeking conjugal rights, or legal notice cause conjugal rights. So, in contrast with what we draft in plaints and what we draft in court, that the subject line must describe the I would say the short period that what you are looking for and against the concerned person. For example, if I have to draft a plaint seeking compensation, so in the subject line I will write plaint on behalf of plaintiff seeking compensation of so and so rupees from Mr. So and so, and whatever I also want. For example, if I want that certain injunction I want, so I will also write that legal notice seeking compensation and injunction against so and so for this and this. So this is slightly different from what we submit in the court. So this is something that we need to look for. And why is this required? Once again, it is of course the discretion of the lawyer, but if the legal notice is not so long, so you need to make it as precise as possible, and you don't need to give so much details where they are not warranted. And that also pleases. No, I won't say that please your client, but it does look good on the paper also that that wherever the details are required, you should mention the details only there, not everywhere else. Now, thereafter, the main body of the legal notice is followed. The first is the in the introduction, or the, I would say, the authority of the writer of the legal notice. For example, if I am writing the legal notice, I would say that under the instructions of, suppose, Mr. Yatin, if Mr. Yatin has asked me to draft a legal notice, I would say that under the instruction of Mr. Yatin, I am directed upon to serve you this legal notice. So you will say that the undersigned, why and how the undersigned is addressing you, because the legal notice is to be sent by the lawyer's office and not by the concerned person. So you need to mention that you are now and you are being authorized by Mr. So and so, in this case, Mr. Yathin, that Mr. Yathin has instructed me to send this legal notice now you have the discretion either to mention that for the alleged I would say for the alleged transaction, or I would you can say that seeking compensation, and legal notice seeking compensation on the basis of facts that are described below. So the first paragraph, it should be that how you are introducing yourself, that you are representing him. Now, once again, this is very different from what we draft in courts, because we don't mention that we are being authorized in the beginning only. We file wakalatnama for that. And in that scenario, we begin with the introduction of the client directly, and not the counsel or the person through whom the plaint or the complaint is filed. Now, once you set the stone for everything, that the beginning is there, the formal introduction, thereafter the subject line, thereafter your own authority as to why are you sending this thing. Now comes the main part. Now, to begin with, there are 7 to 8 points that you need to take care of. First is that who is your client? What does your client do? Second, who is the addressee? What does the addressee do? So these two parts need to take care of. That you give one or couple of line details of both the parties, because that is making flow. If you see simultaneously, that first the authority, the second is the client's information, the third is the other party's information, the fourth, and that is one of the most important thing, is the relation of both the parties. For example, if both the parties are neighbors, you must mention that both the parties are neighbors, and if they are not neighbors, then you must mention that how these parties are known to each other and how the transaction took place. So this is a base of something that that a person needs to prove in a court of law, that okay, through this way, so for example, through so and so person, you get to know about the addressee only. So you need to mention this thing, not in detail, of course, just in one or couple of lines. That will do. However, if the case requires, if the fact requires to go in, to appreciate certain facts, you may do so, but in generality, it's not required. Thereafter, you will say and you will talk about the transaction. Now that before transaction, the relation is very important, because on the basis of relation, you get to know, or I would say that you have the confidence to deal with the other person in that particular scenario, which can give birth to the transaction. Suppose if we are taking the example of legal notice seeking compensation. So compensation in the sense that a transaction happened and the other party does not pay. So the first is, as we talk about, that both the parties knew each other by so and so reason, and on the basis of that relationship, you already have the confidence in the other party that the other party is bona fide, and whatever he or she will do, that will help. That will be done in good faith only. So that's how the legal transaction took place. Now, legal transaction, thereafter, you will say that on the basis of that legal transaction, there are compliances that need to be followed by both the parties. You may describe the legal compliance if the legal transaction details, if that's required. For example, if the legal transaction happened on the basis of credit, so you will say that that such and such legal transaction happened on the basis of credit. However, my client has done its part. Now, in this following paragraph, you will say that your client has performed so and so service, or has provided good in XYZ manner, and the date also. Now, here, whatever the details are there, you should be very careful while mentioning all those details, including the date also. Suppose if you have mentioned that transaction occurred on 13th of January, but the transaction actually occurred on 14th of January, for example, and the other party can come up and prove, suppose can prove that on 13th he was not in the town. So the entire the entire hard work and the entire process of the entire litigation may get jeopardized merely because of wrong information, or I would say because of the typo also. So that's why I said that the every details is important in the legal drafting. Had it been just normal communication, you could have said that you have stated that around 13 or 14 you have stated. Now there may be scenarios where the party is actually not aware about the date. He will say, he can come to you and say that Mr. Counsel, that last year, somewhere in the middle of last year, this transaction occurred, and the transaction occurred in good faith, and no document was available. And this does happen even today. This does happen. So in those scenarios when you are not aware, you will say that in an on and around so and so, and try to try to work with the client to find out the exact date. Because if you say that around the middle of the year, again that is not something that is appreciable, because that's a loose drafting. As I say that the particulars are so important in drafting that you tend to focus on that. And in certain scenarios you just ask for the client that try to remember as to when you were there. Suppose if he is sure that it is between August to September, so you can say that then you can mention that it may be around some Independence Day whether this happened or not. So this is something that does not reflect in your legal drafting, but it definitely does. It is a part of legal drafting only reason because you have to attain and you have to discover facts from the client communication only. Because tomorrow he will say that he has already served every information to the lawyer, and the lawyer has not provided or has not worked with him. Because we need to understand that we know the importance of the details of every drafting, but not the client. For client, let's say that middle of year it could be August or it could be September, and it's not just we are doing any shallow service. We are there to provide what we have been asked for. So our main agenda is to provide the exact details. So in this scenario, we have to work with the client, and of course it depends upon the nature and it depends upon the exigency also as to when it is required and how urgently it is required. So we again need to work on that also. Thereafter, you will say that despite your compliance, the other party has not complied. Now, in this paragraph, you may mention, you may go ahead with certain details, but of course, in legal drafting, I do not appreciate the details because uh, first, that's not required because it is not something that you need to prove in a court of law that the transaction so and so happened. And of course, we will also cover one thing, that there is some paragraph which allows you to to highlight or to add something in a court of law. So, but in this paragraph, you need to mention the details of the other party as to other party how when the other party has committed the default. For example, the other party has taken the loan and taken the services without paying anything at that point of time. So you need to mention clearly first that he has taken the services or he has enjoyed the service. Second, that he agreed that he will pay back the money after 5 days, 10 days, whatever the case may be. Third, that on that particular day he did not pay the money. And the fourth, that you may mention that even after 10 days or 1 month or so, the payment was not given, and of course the goods or services are being enjoyed or are still in the possession of the other party. So that is, of course, you also rule out the scenario of return of some. Suppose if it's goods, that you also rule out the possibility of returns of goods. So these 4 5 things here that you need to mention, and thereafter you say that that as a normal person, and in most of the scenarios it happens that a person tries a lot of time before knocking the door of the council, that on so and so occasions that my client has requested you to to look into the matter and consider whatever is to be considered. And despite so many requests, you have turned away and not followed your contract, and thereafter my and now you have stated that the other party has not followed. You have requested. Now the third point is that how you are suffered. You can say that you are suffering because of so and so reason, because of so and so thing, that you are unable to perform something, or that has caused something on your personal life, or not on personal life in such that you are in need of some money, that you can say. Or if there is something apart from compensation case, for example, if it's a defamation case, you need to mention the effect of that defamatory post. For example, if you say that, due to that defamation post, the client's image has substantially damaged. So you need to mention, or at least highlight, I would say, wherever possible, the impact of the non-compliance of the other party, because that provides everything in a legal notice, that okay, the transaction happened, you have completed your stuff, other party did not do so, and despite request the other party is not doing. And lastly, of course, as I said, the impact of the entire transaction. Thereafter, you can mention, after mentioning, you will say that your conduct may attract certain provisions of law based upon the transaction. For example, if it's defamatory, it could be section 499 and 500 of IPC. If it's compensation, if it's suppose cheating, it could be 420 of IPC. And suppose if it's not criminal, you can say that that may allow your client to take some actions as per law against you. And thereafter the same is followed by the out of mutual settlement, and the hope of in the hope of speedier settlement of the same, you are providing 15 days or 30-day service, 30-day time period to the other party after receiving this notice to comply and to settle the matter. It does make sense, because you can't expect the other person to just comply with whatever he has not been complying for so long. So at least 15 days, something that you should take care of. Again, it is not mandated that you need to provide before 15 days. It could be less than 15 days also, but at least this is a reasonable time that shows the bona fide intention of your own client also. And lastly, you can say that, of course, the cost would be there to draft a legal notice. You can say that so and so cost depends upon what you deem fit to ask from the other party, that the other party is also liable to pay XYZ amount for this for drafting this legal notice. And thereafter the same must be signed by you at least. And if there are suppose two addresses, you can say that the copy to address this and this also. And if there are other interested party, you can copy them too also. But in most of the scenarios, that's not required. And last, one more thing, just above signature, you must mention that the copy is retained in your office for future reference. It because that allows, and that gives the validity of the notice that you have. And as I told you that the legal notice must be signed by the council, but it is not mandated that the same must be signed by the client. But for the abundant precaution, and for for validity also, I always I always prefer that the same must be signed at least on the last page by the client. And it would not be a bad practice if every page is signed by the client also. So that shows that saves the particular council from any misconduct, or any thing that may go here or there, because the notice when it is signed by the client, shows that the client has read it. And suppose the client is not well versed with the language in which you have written, like in most of the cases it should be English, and suppose if the person is not well versed, you can write in one line in the footing that though the notice is drafted in English, but the same is being read over to the client in Hindi, and thereafter he has signed all the scenario. Though again, that once again it is hardly followed, but if you want to save, or just out of the abundant precaution, you can write this line. Otherwise, the signatures on every page will do. And I think that's how the legal drafting of something, that I would say the fundamental of every drafting is nothing but legal notice only, and thereafter a person can move ahead with drafting of claims, notices, replies of legal notice, and thereafter so and so forth. And I think, Atin, that we have covered about the legal notice drafting. Is there something that you may like to highlight or you may like to add? Hello. Hello. Hello, Atin. Can you hear me? At- Atin, I think I have lost your connection if I'm not.
Am I audible, sir?
Yes, yes. Now you are audible. I'm saying that
Yeah.
probably we have covered almost everything regarding the legal notice. Of course, the reply would be there, and thereafter the same may be followed by litigation. But I think that that may not allow us to cover everything in one session only. However, if you have something to add or something to ask, that would be very good.
First of all, thank you so much, sir, for sharing your knowledge and experience with us. So now we are open for questions. Mm, Sir, do we need to highlight the sections under which we intend to move the case to court?
Sorry. Can you repeat the question?
Mm, There is a question by Devsmita Dinesh. Sir, do we need to highlight the sections under which we intend to move the case to court? Like, do we have to specifically mention the
Actually,
sections?
see, you don't need to specifically mention the section because just one thing that I perhaps just missed it that you may add. Of course, that's not necessary, and then I will come down to this question. As I told you that we do not mention every details of the facts, correct? Now, suppose you want to add the facts in the later stage of drafting or in the later stage of case. Now, what would you do? Now, you can say that the details are not being mentioned herein for the sake of brevity. However, the client reserve his rights to mention it or to disclose it in the appropriate court of law. And if suppose if there are series of alleged offences, you can say that the other party has committed series of alleged offences, and the client reserve his rights to explain, give details, and take action against all those offences which are not elucidated in this notice. Now, coming to the question in hand, the question states that whether we need to mention the concerned section under which we may proceed with law. I don't think so that you need to you have to do it. You can easily say that the appropriate legal remedies or appropriate legal actions can be taken against you. However, if it's a very simple thing, then it's advisable because if suppose if it's a compensation case, if the other party is not paying, it means that somewhere down the line the cheating is being committed. So you can say that the section 420 would be there. And suppose if it's mandated by law, then you have to mention at least the concerned, I would say, area of law where under which you are going to file the case. For example, you can say that if the same is not being followed, then you will submit and you will file the complaint before the magistrate under the Negotiable Instrument Act. And always keep in mind that despite and suppose even if you write the concerned provisions, you also add that and other provisions of law, because as I told you as I experienced that after even after a few meetings the client may come up and add something new. So you can't be very sure unless of course the facts warranted, and that allows you also to add something in later course of event, because that it may happen that despite the best or the detailed knowledge given by the clients, counsel missed something, and thereafter you see okay that you have missed something. So if you have not stated in the the legal notice, you may find it difficult, or at least the other person can say that that now he is coming up with something else. So of course that won't hamper any of the case, but it doesn't make sense to create certain issues when you can win the case without any fuss. So always add these precautions in the legal notice, because you may never know that that certain situation may arise, and that can actually allow you to amend, expand, and if I say that, alter the legal notice in the concerned case, that to be followed.
We have one more last question. What
Mhm.
about statutory notice?
Statutory notice. As I told you, this statutory notice is to be given. You don't have the flexibility whether to follow it or not. For example, in section 138 cases, check bounce cases, after suppose if I present some check and the check gets bounced, I will have merely 30 days after receiving the notice from the bank that the particular check is bounced. I have to send the legal notice to the other party. I don't have the luxury of not sending the legal notice and then filing the case. The case will be uh, the case will be dismissed then and there only, that the compliance has not been followed. So whatever the statutory notice will be there, we have to follow it, and in light of the timeline that is provided in the concerned section. For example, if 138 time limit is not being followed, then there are so many scenarios where just 2 day delay has hampered the entire case for the party. And in DRC also, as I told you, that there is a mandate of sending legal notice to the tenant also for someone if you are filing under section 14 also. So you have to follow it. You have to mention the consent provision under which you are filing the legal notice, and then you can say that if the same is not being adhered by the other party, you may take appropriate action as provided under law. But in the subject line, you must mention that under this section, this notice is being sent, and you also need to mention that that if not mentioned, but you need to highlight the time limit that is followed by a good self.
With this, we have came to the end of the session. Thank you so much, Lalit sir, for taking out time from your busy schedule for taking this session. And I would like to thank the audience for patiently listening to us. Now we are ending the live stream. Thank you so much, sir.
Thank you so much, Session.